Hello guys and welcome to EduShaman YouTube channel. I'll be covering Polity by M. Lakshmikant in this series. We'll go through the first chapter, that is the historical background. So before we have this constitution, there needs to be a body which creates this constitution, which uses this constitution. Okay, and this body is called as the Constituent Assembly. So, before any nation is governed, we should know how this nation should be governed or will be governed. And this constitution happens to be a framework within which all the laws in that particular nation are enacted. So, when it comes to India, we have our history with the British, and because of the interaction which we have had with the British, because they ruled us over the years, our constitution is influenced to a very large extent by this history. So the first chapter in this book is called as Historical Background. The British came to India in 1600 as traders in the form of East India Company, which had the exclusive right of trading in India under a charter granted by the Queen Elizabeth I. In 1765, the company, which till now had purely trading functions, obtained the Diwani, that is, the rights over revenue and civil justice of Bengal, Bihar, and Odisha. So basically, the British came here as traders. There were certain things which were in high demand in Europe but were available in India or Asia, and these traders used to take it from here and sell it in their country for a higher price. So, the people who came to India were actually a part of a company called East India Company. It's just like today's Geo or some other company. They came here for trade, but with time they settled down here and they learnt our culture, how Indians operate. They needed some kind of a political stability in their trading, and then they started interfering with the local politics in the way these kings and queens used to rule India, so that they could further their objective, so that there can be an atmosphere in which there could be furtherance in their trade, in which they prosper. This started its career as a territorial power. That is, after the obtaining of the Diwani, the British assumed to be territorial powers. In 1858, in the wake of the Sepoy Mutiny, the British Crown assumed direct responsibility for the governance of India, and this rule continued until India was granted independence on August 15, 1947. And we all know in 1858 there was something called as Sepoy Mutiny, and after which the British Crown, that is the British Queen, assumed the direct responsibility for the governance of India. So from then onwards, from 1858, it's not a company which ruled India, but it's actually Britain in itself. When I say Britain in itself, it means Britain as a nation. With independence came the need for a constitution. Hence, a Constituent Assembly was formed for this purpose in 1946, and on January 26, 1950, which we call as the Republic Day, the Constitution came into being. The various features of Indian Constitution and polity have their roots in the British rule. There are certain events in the British rule that laid down the legal framework for the organization and functioning of government and administration in British India. These events have greatly influenced our constitution and polity. That is, there are two significant stages. One is the company's rule, and the other is the crown's rule after 1858, as I told you. During company's rule, there were a certain series of acts that took place. And these acts are important because they shaped the Indian constitution as it is today. They shaped the way India was ruled, and it reached a point in 1947, after which India took over. So, the first important rule is that of the Regulating Act of 1773. This act was of great constitutional importance as it was the first step taken by the British government to control and regulate the affairs of East India Company. See, the British government, which is located in Britain, took its first step to regulate a British company, that is East India Company. So it is the first time this has happened that the sovereign nation Britain took the first step to regulate the affairs. That's why Regulating Act of 1773 becomes very important. It recognized for the first time the political and administrative functions of the company. Until then, the East India Company could behave as they liked, but for the first time, the Britain as a nation took to cognizance the political and administrative functions of the company, and hence it also laid down the foundations for central administration in India. Let's go through the features of the Regulating Act 1773. It designated the Governor of Bengal as the Governor General of Bengal. So there were three governors: Governor of Bengal, Bombay, and Madras. There were three presidencies. But now the Governor of Bengal is not governor; he is the Governor General, and the rest two, they are only governors. That means Governor of Bengal is now superior in hierarchy. And an executive council of 4 members was created to assist him so that he doesn't take arbitrary decisions of his own. So now what has happened is there will be a collective decision making where the 4 member executive council was created. And first such Governor General of Bengal was Lord Warren Hastings. The governors of Bombay and Madras presidencies were now subordinate to the Governor General of Bengal. Earlier, these three presidencies were independent of each other and could take independent decisions. So we can see a sense of uniformity coming in, with the Governor General of Bengal being the most superior person in British India. It provided for the establishment of a Supreme Court at Calcutta. So we need a Supreme Court when you have one nation, right? So slowly this sowed the seeds for one British India. So Supreme Court of Calcutta was established, comprising of one Chief Justice and 3 other judges. It prohibited the servants of the company from engaging in any private trade or accepting presents or bribes from the natives. So the company's employees, their activities were still further regulated. Earlier there was no tight control on them, but now onwards the government in Britain would exercise its control over the company's functioning, over its employees. It strengthened the control of the British government over the company by requiring the Court of Directors to report on its revenue, civil, and military affairs in India. Now, the British East India Company, their directors, who were called as the body which was called as the Court of Directors, the governing body of the company, had to report to the British government located in London. They had to report on the revenue, civil, and also the military affairs. Amending Act of 1781. In a bid to rectify the defects of the Regulating Act of 1773, the British Parliament passed the Amending Act of 1781, also known as the Act of Settlement. The features of this act were as follows. It exempted the Governor General and the Council from the jurisdiction of the Supreme Court for the acts done by them in their official capacity. Similarly, it also exempted the servants of the company from the jurisdiction of the Supreme Court for their official actions. This is similar to the present day immunity which is enjoyed by the President and the governors. If there is any act which is committed by them in their official capacity, then they enjoy a certain kind of an immunity. It excluded the revenue matters and the matters arising in the collection of revenue from the jurisdiction of the Supreme Court. Here we come to know that the British interests were mainly in revenue, and any matter that arose in collection of revenue was excluded from the jurisdiction of the Supreme Court, so that revenue collection remains intact. It provided that the Supreme Court was to have jurisdiction over all the inhabitants of Calcutta. It also required the court to administer the personal law of the defendants, that is, Hindus were to be tried according to the Hindu law and Muslims were to be tried according to the Mohammedan law. So the British, they never interfered in the religious affairs until and unless it really served their interests, because this is something which was very touchy with the Indians, and they didn't want to touch this topic because law and order was very important for them, so that they could conduct their trade in an easy manner. It provided that the Supreme Court was to have jurisdiction over all the inhabitants of Calcutta. It's fair enough. So required the court to administer the personal law. So the court here doesn't decide on what the law should be. It only administers the law as per our ancient customs. Hindus as per the Hindu law and Muslims as per the Mohammedan law. It laid down that the appeals from the provincial courts could be taken to the Governor General in Council and not to the Supreme Court. So the Governor General in Council was made the appellate body after the provincial courts. From the provincial courts, the direct appellate body would then be the Governor General in Council. It empowered the Governor General in Council to frame regulations for the provincial courts and councils. So here we have the executive undertaking judicial functions. First, he acts as an not he, it's Governor General in Council, that is, Governor General and the members of his Executive Council will undertake judicial functions, and also they would regulate the courts, the provincial courts and councils. The next act, the Pitt's India Act, is of very much importance. Pitt's India Act was passed in 1784. The features of this act were as follows: distinguished between the commercial and political functions of the company. Now, this company, which came to India as a trading company, it gained some territorial control and rights to collect taxes, revenue. So, it also had political functions with it, like administering the law and deciding on the taxation rate, maybe. So, these are two different functions. One is to operate as a company, and other is to operate as the ruler, what we call as a political function. It allowed there was a distinguishment which was being made between the commercial and the political functions of the company. It allowed the court of directors to manage the commercial affairs, but created a new body called Board of Control to manage the political affairs. Thus, it established a system of double government. There was a Board of Control which was created. Earlier, there were directors. So directors were now given only commercial function, and this board of control was operated from Britain. It empowered the board of control to supervise and direct all operations of the civil and military government or revenues of the British possessions in India. Thus, the act was significant for two reasons. First, the company's territories in India were for the first time called the British possessions in India. So there was an acknowledgement that whatever the East India Company owned in India were actually possessions of Britain as a nation. And secondly, the British government was given the supreme control over company's affairs and its administration in India. So British government now really interfered with how the company is handling itself in India, how the company is operating in India. Next is the Act of 1786. In 1786, Lord Cornwallis was appointed as the Governor General of Bengal. He placed two demands to accept that post. First is he should be given the power to override the decision of his council in special cases, We know that the Governor General had an executive council of 4 members. So 3 members of the council are pro any decision which the Governor General himself is against. Then they could override the Governor General. But what Cornwallis here emphasizes is that he demands is that he should be given the power to override the decision of his council in special cases. That is, even if all the 4 members in this executive council are against him regarding any decision, still he should be able to override them. And then he can call it as a special case. That's what happens in politics. So he should be given that power. That was his demand, which was met apparently, because that's how then he became the Governor General of Bengal in 1786. His second demand was he would also be the Commander in Chief. Accordingly, the Act of 1786 was enacted to make both of these provisions to suit his demands. I don't think this act is that important because it's more like a tailor made thing for Lord Cornwallis. Then comes the Charter Act of 1793. The features of this act were as follows. It extended the overriding power given to Lord Cornwallis over his council. That is, the Governor General can override the decision of his council. So, this was given to all the future Governor Generals and governors of presidencies. Earlier, it was an exception for Cornwallis alone, but in the Charter Act of 1793, this power to override the decision of the council was given to all the Governor Generals and the governors. Second, it gave the Governor General more powers and control over the governments of the subordinate presidencies of Bombay and Madras. So the Governor General of Bengal became more powerful. Now, and the presidencies of Bombay and Madras became even more subordinate to that of Bengal. It extended the trade monopoly of the company in India for another period of 20 years. So basically, East India Company had the monopoly over the trade in India. That is, some other company cannot trade. It's like you give the charter to Jio, then Airtel cannot trade. Something like that. So this trade monopoly was extended by a period of 20 years. So from 1793 to 1813, only East India Company could trade in India. Fourth point, it provided that the commander-in-chief was not to be a member of Governor General's Council unless he was so appointed. So what it means is that until that point of time, the commander-in-chief, the supreme commander-in-chief for British India, the military commander, was by default a member of the Governor General's Council. But now explicitly they told that until he is appointed as such, he, by virtue of his position, would not be a member of the Executive Council. Fifth point, it laid down that the members of the Board of Control and their staff were henceforth to be paid out of the Indian revenues. So their salaries would come out of the revenues which are generated in India. So, what are the important features of this Charter Act of 1793? One important feature was that increase in power of the Governor General of Bengal, and the Governor General can override the decisions of his council, extension in trade monopoly to the East India Company for another 20 years. So, these three things we can say are very important. Charter Act of 1813. The features of this act are as follows. It abolished the trade monopoly of the company in India. This is very significant because East India Company is now losing its hegemony, it's losing its power, its status and influence, and the British government is exercising itself more and more in Indian affairs. The Indian trade was thrown open to all the British merchants, so anyone else hailing from Britain who was a merchant could now trade in India and not necessarily East India Company. However, it continued the monopoly of the company over trade in tea and trade with China. So the company still retained its monopoly over trade when it comes to two things, that is tea, that is chai, and trade with China. Second point, It asserted the sovereignty of the British Crown over the company's territories in India. Third, it allowed the Christian missionaries to come to India for the purpose of enlightening the people. Fourth, it provided for the spread of Western education among the inhabitants of British territories in India. So it promoted Western education, we can say. Fifth, it authorized the local governments in India to impose taxes on persons. They could also punish the persons for not paying taxes. So just like we have these urban local bodies, now they could impose taxes on people and generate revenue at their own level. Next act is the Charter Act of 1833. This act was the final step towards centralization in British India. Okay, before we go to Charter Act of 1833, what are the important things that happened in Charter Act of 1813? One is East India Company's monopoly came to an end, except for trade in tea and trade with China. Christian missionaries were allowed to come to India, 1813, and Western education was promoted. Local governments were allowed to impose taxes. Charter Act of 1833 was the final step towards centralization in British India. The features of this act were as follows. Now the Governor General of Bengal is being called the Governor General of India. There's a change in name, and vested in him all the civil and military powers. Thus, the Act created for the first time Government of India. So, the Government of India comes into being in 1833. Until then, we had an overall vague system where Madras and Bombay were considered inferior to Bengal. Now, the Governor General of Bengal is clearly nominated as Governor General of India, denominated as Governor General of India. Thus, the Act created for the first time Government of India, having authority over the entire territorial area possessed by the British in India. So, Lord William Bentinck becomes the first Governor General of India. Second point, it deprived the Governor of Bombay and Madras of their legislative powers. So, earlier we had Bombay deciding for what laws should be implemented in Bombay and Madras deciding what laws should be implemented in Madras. So there are no legislative powers henceforth vested in Bombay and Madras. The Governor General of India was given the exclusive legislative powers for entire British India. Now it won't be like the Bengal is deciding for Madras. Now the designation is Governor General of India. So entire India, the laws will attain a certain form of uniformity. The laws made under the previous acts were called as regulations, while laws made under this act will now be called as acts. So anything which after 1833, if any law is passed, it is called as an act. Until then, it was called as regulation. Third, it ended the activities of East India Company as a commercial body, and East India Company is now a purely administrative body. This is post 1833. It provided that the company's territories in India were held by it in trust for His Majesty, His heirs, and successors. So the company held the British monarch's territories in India in trust for His Majesty, His heirs, and successors. So there is an assertion by the British monarchy that the territory that you own is my territory and you own it, you keep it with you in trust for me, my heirs, and successors. That is whoever comes next in line. The Charter Act of 1833 attempted to introduce a system of open competition for selection of civil servants and stated that the Indians should not be debarred from holding any place, office, and employment under the company. However, this provision was negated after opposition from the Court of Directors. Basically, it was a progressive thing which they said that there should be an open competition. Otherwise, there would be direct recruits from Oxford and Cambridge and other universities in England. Now you would have an open competition for selection of civil servants. And Indians are not barred from holding any place office employment under the company. But the court of directors, the people who had already established themselves in East India Company, opposed this because they would lose their influence if we had more and more Indians in the administration. And this provision did not come into force. Charter Act of 1853. This was the last of the series of Charter Acts passed by the British Parliament between 1793 and 1853. It was a significant constitutional landmark. The features of this act were as follows. It separated for the first time the legislative and executive functions of the Governor General's Council. It provided for addition of 6 new members called legislative councillors to the council. In other words, it established a separate Governor General's Legislative Council which came to be known as Indian Legislative Council. The legislative wing of the council functioned as a mini parliament adopting the same procedures as the British Parliament. Thus, legislation was for the first time treated as a special function of the government requiring special machinery and special process. So guys, now for the first time we have something called as the Legislative Council. Earlier on we just had this Executive Council which used to do the legislation and which used to execute the policies which were created by they themselves. Now we have separate set of people who are going to legislate, and we already have the Executive Council to execute what has been legislated. So legislation is treated as a special function of the government which requires a special machinery. And at the same time, it also fulfills the doctrine of separation of powers to some extent was brought in. The procedures of the mini parliament were same as that of the British Parliament. Like, see, for example, in Indian Parliament, we have this question hour, 0 hour, or how we can ask questions to the Parliament, how a member of the Parliament can ask questions to the government. So, like start questions, unstart questions. These are the procedures by which the Parliament functions. So, these were directly adopted as same as the British Parliament. The second point, it introduced an open competition system for selection and recruitment of civil servants. The covenanted civil service was thus thrown open to Indians also. Accordingly, the Macaulay Committee, the Committee on the Indian Civil Service, was appointed in 1854. So, an open competition system is brought in for selection and recruitment of civil servants. As I told you, there were 3 tiers of civil service in India, and covenanted civil service occupies the highest of place. Like, it's equivalent to modern day IAS, IPS, etc. And this was thrown open to the Indians for the first time through an open competition. And Macaulay Committee was appointed on Indian civil service. It extended the company's rule and allowed it to retain the possession of Indian territories on trust, very important word, on trust for the British Crown, but it did not specify any particular period, unlike the previous charters. This was a clear indication that the company's rule could be terminated at any time the Parliament liked. See, the company's rule was extended. The legality given to East India Company's rule in India by the British Parliament was extended every 20 years. So in 1793 we have the Charter Act of 1793 which extended the East India Company's legality to rule India till 1813. In 1813 we have Charters Act of 1813 which had its term till 1833, 1833 to 1853 and so forth. But in 1853 no such time period was mentioned defining the period for which East India Company would rule India. It means that the company's rule could be terminated by British Parliament anytime they like. Anytime they like, they could take over the Indian rule from East India Company. It introduced for the first time local representation in the Indian Legislative Council
Of the six new legislative members of the Governor General's Council, four members were to be appointed by the local governments of Madras, Bombay, Bengal, and Agra. So, here again, we see that there is a central legislative council, but the provinces have a say. They have a say in who is going to be the legislative council. So, there is a proper representation of provinces in a central body, like how we see in Rajya Sabha. In Rajya Sabha, what happens is that the members of the Rajya Sabha are elected by the members of the state legislative assemblies. That is why we call it Rajya Sabha, that is state council, council of states. So here too we have the system where out of six people, Madras will give one, Bombay will give one, Bengal will give, and Agra will give one. Okay. So the next part is okay. So now we enter into the next chronology, that is the Crown's rule, that is the direct rule by Britain in India. The Government of India Act of 1858. The significant act was enacted in the wake of Revolt of 1857, also known as the First War of Indian Independence or the Sepoy Mutiny. The act, known as the Act for the Good Government of India, abolished the East India Company and transferred the powers of government, territories, and revenues to the British Crown. The features of this act were as follows. It provided that India henceforth was to be governed by and in the name of Her Majesty. Earlier, India was governed by EIC in trust for Her Majesty, but now it is was to be governed by and in the name of Her Majesty. So the word for has been replaced by the word by, which means the Britain would directly exercise its control over India. It changed the designation of the Governor General of India to that of the Viceroy of India. Earlier we had the term called Governor General, which is a very administrative term. Now we have a term called Viceroy. Viceroy is like our ancient kings had a certain representative who would represent that kingdom in some other nation, in some other kingdom. So this particular post is called as a Viceroy. So now that we are directly under the British Kingdom, the British Kingdom's Viceroy is now stationed in India. So this name change is pretty significant, although it seems insignificant and it's just a name change. It also emphasizes on the fact that the crown is now directly ruling India. So the Governor General will henceforth be called as the Viceroy of India. Lord Canning thus became the first Viceroy of India. It ended the system of double government by abolishing the Board of Control and Court of Directors. The very reason Board of Control came into existence was to supervise a check on the Court of Directors, that is, people who are managing the East India Company. But now that East India Company does not exist, there is no need for a Court of Directors and hence for a Board of Control as well. It created a new office, the Secretary of State for India, vested with the complete authority and control over Indian administration. The Secretary of State was a member of the British Cabinet and was responsible ultimately to the British Parliament. So now here we have a guy called as the Secretary of State. This guy is a nodal guy. He is located in Britain and he is also a member of the cabinet there. And he has to report on the Indian affairs to the parliament there. If they don't like his answers, if they don't like his functioning, they can remove him and give the post to some other guy, the British Parliament. The Secretary of State interacts with the Viceroy because the Viceroy is head of the British administration in India, and the Secretary of State and Viceroy, these two people act like two nodal points who are interacting with each other, one located in India and the other located in Britain. It established a 15-member Council of India to assist the Secretary of State for India. The council was an advisory body. The Secretary of State was made the chairman of the council. So he gets a 15-member advisory body who can advise him on how India should be run. And if the Viceroy does not adhere to these norms, then probably the Secretary of State would interfere and tell the Viceroy, you don't do things this way, you have to do things the other way. or this is not what the British interests represent. So your style of functioning should suit British interests. It constituted the Secretary of State in Council as a body corporate capable of suing and being sued in India and in England. So, if the Secretary of State in Council is involved in any activity which is malified or which is detrimental to someone in India, then even Indians could sue them. So it acted as a body corporate, which means it acted like a company, like a legal person. A legal person can be sued or also can sue. So say Mr. Rajan versus Secretary of State in Council. You can have a case like that in the courts. That's what they mean. The Act of 1858 was, however, largely confined to the improvement of the administrative machinery by which the Indian government was to be supervised and controlled in England. It did not alter in any substantial way the system of government that prevailed in India. So basically, they are saying that 1858 did not alter the way the administration was done. It did not brought in many changes. Like, say, for example, in 1861 we have, in 1853 we see that there are six people who are now legislative councillors. So this is some kind of a change in the administrative machinery. But 1858 did not alter the way in which India was run. If you see, it created this post called Secretary of State to deal with the Viceroy. So, who is actually located in England. That is what they are saying. It changed the administrative machinery by which Indian government was to be supervised and controlled in England.
The Indian Councils Act of 1861. After the Great Revolt of 1857, the British government felt the necessity of seeking the cooperation of Indians in the administration of their country. In pursuance of this policy of association, three acts were enacted by the British Parliament in 1861, 1892, and 1909. The Indian Councils Act of 1861 is an important landmark in the constitutional and political history of India. Let's see why is it so. The features of this act are: it made a beginning of the representative institutions by associating Indians with the law-making process. So institutions were now representative of the people who are being governed. That means Indians are being governed and Indians are now a part of the legislative process. It thus provided that the Viceroy should nominate some Indians as non-official members of his expanded council. Non-official members in the sense they will not be implementing anything. They are not the part of the executive. They are just people like me and you who will be focusing entirely on legislation and who are not concerned with the British government at all in the ordinary scheme of things. In 1862, Lord Canning, the then Viceroy, nominated three Indians to his legislative council: the Raja of Banaras, the Maharaja of Patiala, and Sir Dinkar Rao. We can assume that these three people may be loyal to the British, but whatever it is still a landmark thing in the Indian constitutional history because these people were not actually British, and there is some kind of a representation given to Indians, whoever they be. It initiated the process, second point, it initiated the process of decentralization by restoring the legislative powers to the Bombay and Madras presidencies. We have seen earlier that the Bombay and Madras presidencies lost their power to make laws and everything was done under Bengal presidency. So, but now onwards, Bengal and Madras can also make their own laws which are specific to their own presidency, their own jurisdiction. So we can see clearly in Charter Act of 1833, the Bombay and Madras presidency lost their power to make laws. So this was reversed. And now both Bombay and Madras can make their own laws. It initiated the process of decentralization by restoring the legislative powers to the Bombay and Madras presidencies in 1861. It thus reversed the centralizing tendency that started from the Regulating Act of 1773 and reached its climax under the Charter Act of 1833. The policy of legislative devolution resulted in the grant of almost complete internal autonomy to the provinces in 1937. So, 1937, we see that the British had a policy of recognizing the local leaders, of recognizing the states, and granting it as much autonomy as possible. This they did to weaken the Indian national movement, which was coming out as an all India movement. So, to weaken the central leaders, they started encouraging the state leaders, and thus they completed this process of devolution of powers more and more to provinces. It reached its peak around this time, 1935 to 1937. In point number three, we'll talk about these things later, and mostly you would read about this in your history. Point number three, it also provided for the establishment of new legislative councils for Bengal, northwestern provinces, and Punjab, which were established in 1862, 86, and 97 respectively. So now we have new provinces of northwestern provinces and Punjab. Earlier you had only Bengal, Madras, and Bombay. So there is some kind of a legislative devolution here. So each region is being recognized that you are a separate region and you can make your own laws. So this happened consequent to 1861, which is also consequent to 1857, where the first war of Indian independence took place. The fourth point, it empowered the viceroy to make rules and orders for the more convenient transaction of business in the council. It also gave a recognition to the portfolio system introduced by Lord Canning in 1859. Under this, a member of the Viceroy's Council was made in charge of one or more departments of the government and was authorized to issue final orders on behalf of the Council on the matters of his department. Guys, Viceroy's Council acts like a cabinet, okay? And now a portfolio system was introduced by Lord Canning in 1859. In portfolio system, if you are assigned a particular ministry, say food supplies, then you can decide on any matter that is concerned with food supplies. So that kind of authority has been given to a member of the council. You can draw an analogy with the modern day ministers. So this is something important. And the point number 5, it empowered the viceroy to issue ordinances without the concurrence of the legislative council. We have ordinance even now in our present day constitution. During an emergency, the life of such an ordinance was 6 months. Even now we have the life of an ordinance which lasts for 6 weeks actually. Anyways, we'll make the comparison later on when we move to the relevant chapter. So guys, what's important in the Act of 1861? One is the portfolio system was brought in. Second thing, he could actually make laws. So we have a semblance of a legislative council here in 1861, but still he can override the legislative council, imperial legislative council as they used to call it. So, and there was a process of devolution of powers to provinces which started, and new provinces were set up. This point, fourth point, which says Viceroy to make rules and orders for the more convenient transaction of business in the council. Even in present day constitution, we have this analogy where the president has the power to make rules and orders for the more convenient transaction of business. So we'll look into it when we move to that particular chapter. So let's move to the next act, that is Indian Councils Act of 1892. We can see a huge gap here of 30 years between 1861 and 92. The features of this act are, it increased the number of additional, that is non-official members in the central and provincial legislative councils, but maintained the official majority in them. So we have legislative councils wherein we have officials serving as the legislators, and there are non-officials as well. So they have increased the number of non-official members in the legislative council, but still officials are more in number. Like you have say 10 officials, then you have only 8 non-officials, something like that. Exact number is not required. The point number 2, it increased the functions of legislative councils and gave them the power of discussing the budget. This is important. First time you were allowed to discuss the budget and addressing questions to the executive. First time you were allowed to discuss the budget in 1892. So what is important here is that until this time, until this period of time, and also in the future, it's always seen that the executive council is far more superior than the legislative council. This is because executive council mostly comprised of people who were British and who were actually a part of the colonial mechanism. People in the legislative council need not be a systematic part of the colonial mechanism. Colonial mechanism, I mean that people who are here to exploit our resources as foreigners, because legislative council will have Indians as well. So when you are actually giving a power for the legislative council to discuss the budget, it's like you are empowering a certain part of the mechanism system where Indians can also be a part of. We go to the third point. It provided for the nomination of some non-official members of the Central Legislative Council by the Viceroy on the recommendation of the provincial legislative councils and the Bengal Chamber of Commerce, and that of the provincial legislative councils by the governors on the recommendation of the district boards, municipalities, universities, trade associations, zamindars, and chambers. Basically, now you will have nominated members, and these people will be non officials. So they can be Indians, mostly Indians. They are appointed, nominated by the Viceroy, but on the recommendation of whom? For Imperial Legislative Council or Central Legislative Council, these are recommended by the provincial legislative councils like Madras, Bombay, Punjab, and Northwest Frontier Province, and Bengal Chamber of Commerce, because that was a big trade body then, body of industrialists. So these people can may have an internal elections among themselves that okay, from Bengal Chamber of Commerce we will recommend person A. So to decide that amongst themselves, they might have had a form of election or they might not have had. There could have been an unopposed candidate who was nominated by Bengal Chamber of Commerce, whose name was given to the Viceroy, and Viceroy will in turn nominate him, recommend him. Okay, so the recommendations came from provincial legislative councils and Bengal Chamber of Commerce. But to provincial legislative council, the recommendation should come from a body which is below the state level. So below the state level, we have these district boards, municipalities, universities, trade associations, zamindars. So zamindars were also given this power. So they were actually recognized. So it was not clearly an egalitarian society until then. Zamindars and chambers. 1892 Act made a limited and indirect provision for the use of election in filling up some of the non-official seats, both in the central and provincial legislative councils. The word election was, however, not used in the Act. The process was described as nomination made on the recommendation of certain bodies. So, as I said, guys, indirectly there was a scope for election. Like if Provincial Legislative Council of Madras say has 100 people, and they have to send 2 people to the Imperial Legislative Council or Central Legislative Council, they would vote amongst themselves that okay, Mr. Ramakrishnan should be sent or Mr. Shivaram should be sent. They would vote who has to be sent, and this indirectly promoted elections in these councils. Although the word elections was not used anywhere, the word used was nomination made on the recommendation of certain bodies. How these certain bodies would recommend is something for them to decide. So let's go to the next act, that is also after a period of 17 years, and you might be very familiar with this act, Indian Councils Act of 1909. The act is known as Morley Minto Reforms. So the Secretary of State's name comes first. Morley, who was then the Secretary of State for India, and Minto, who was the Viceroy of India. As we have seen earlier, Secretary of State, he stays in Britain, is a member of the British cabinet, and he's a nodal point in Britain to deal with the nodal point in India. In India, the nodal point would be the Viceroy. So these two people are of critical position. Secretary of State can direct the Viceroy that Viceroy, you get these things done, or you do it in this manner. But Viceroy is actually the guy who is administering India and not Secretary of State. Secretary of State supervises the Viceroy. So let's get into 1909 Act. The features of this act were as follows. Number one, it considerably increased the size of the legislative councils both at the central and the provincial level. The number of members in the Central Legislative Council was raised from 16 to 60. It's a significant rise. The number of members in the provincial legislative councils was not uniform. So, for a larger province, you have a larger number of people. It retained official majority in the Central Legislative Council but allowed the provincial legislative councils to have a non official majority. Until 1892, we had official majority in both Central Legislative Council and Provincial Legislative Councils. But from 1909, you have non-official majority in the Provincial Legislative Councils. The point number 3, it enlarged the deliberative functions of the legislative councils at both levels. For example, members were allowed to ask supplementary questions, move resolutions on the budget, and so on. Until now, they were allowed only to debate and ask questions, and they would get an answer. They couldn't ask further questions, the members of the legislative councils. Now they can ask supplementary questions and also move resolutions on the budget. Resolution, guys, is like expressing your opinion. It doesn't have much of a legal standing. It's like I move a resolution in state council, state legislative assembly, that the central government should behave this way. Central government did not listen to me. I am not a factor. States are irrelevant in central's decision making. I mean, legally, I am saying the opinion matters because central does not need to listen to the state. But states can pass resolution, right? In modern day constitution, states can pass resolution. So, similarly, resolution is just opinion. So, these legislative councils could move resolutions on the budget. But this wouldn't significantly impact the budget because the Viceroy's Executive Council would decide on what the budget would be. So, even though these legislative councils had some power, it was very limited. And when it comes to financial questions, mostly the power would be in the hands of the officials. Point number 4, it provided for the first time association of Indians with the Executive Council of the Viceroy. This is very important. Until now, as I told, Executive Council is seen as a very superior body when compared to the Legislative Council. And it is meant for the core British people, core officials. And this was for the first time in 1909 that an Indian became a part of the Executive Council of Viceroy and also of the governors at the state levels. Satyendra Prasad Sinha became the first Indian to join the Viceroy's Executive Council. He was appointed as a law member. Under the portfolio system, he got this law portfolio with him. Number 5, this is very important. It introduced a system of communal representation. First time we can see communal representation coming in. Communal representation for Muslims. This is also a fallout of 1905 when Bengal was divided into two states. There was a rise of revolutionary movements in Bengal, and the British wanted to curb it. And then what they did, they partitioned Bengal. So there was a system, there was a British policy of divide and rule, which started then. And they encouraged the communal representation for Muslims by accepting this concept of separate electorate. Separate electorate is Muslims will vote only for Muslims. There would be a certain number of seats which are reserved for Muslims, and only Muslims get to vote. Under this, the Muslim members were to be elected only by Muslim voters. Thus, the act legalized communalism. and Lord Minto came to be known as the father of communal electorate, Minto the Viceroy. Number 6, it also provided for the separate representation of presidency corporations, chambers of commerce, universities, and zamindars. So there is some kind of a reservation now for presidency corporations. Presidencies were only Bombay, Madras, and Bengal. So not everyone gets to have this. So if you are from Bombay Corporation, you will have some representation. But if you are from Chandigarh Corporation, you won't because you are not a presidency corporation. Chambers of Commerce, universities, and zamindars. So zamindars were again cropped up by the British because they were loyal to the British. So it's all interrelated. The history, the social situation then, and how these laws are being enacted. Let's see why this Act of 1909 is important. First thing is that it introduced separate electorate. Second thing, it increased the number of members in the Central Legislative Council from 16 to 60. It introduced non-official majority in the provincial legislative councils. Supplementary questions were allowed to be asked. Resolutions could be moved on the budget. And first time, Satyendra Prasad Sinha, that is an Indian, was associated, joined the Viceroy's Executive Council and as a law member. So let's go to the next act, Government of India Act of 1919. The Government of India Act of 1919. On August 20, 1917, the British government declared for the first time that its objective was the gradual introduction of responsible government in India. The Government of India Act of 1919 was thus enacted, which came into force in 1921. This act is also known as Montague-Chelmsford Reforms. Montague, the Secretary of State, and Chelmsford, the Viceroy of India. As you know that this act has come during the period of First World War. So Montague and Chelmsford came to India around 1917. So when this war was going on, and they had to show some concessions to Indians. And let's see what is there in this act. It relaxed the central control over the provinces by demarcating and separating the central and provincial subjects. The central and provincial legislatures were authorized to make laws on their respective list. However, the structure of the government continued to be centralized and unitary. Basically, what happens is that the provinces were now told that these are your subjects, you should administer them, and they were given a certain kind of freedom to administer their subjects. So it is actually the beginning of the seventh schedule, that is Union List, State List, and Concurrent List. Although it's not explicitly mentioned as such, but it's something like that. So let's go second point. It further divided the provincial subjects into two parts, transferred and reserved. The transferred subjects were to be administered by the governor with the aid of ministers responsible to the Legislative Council. The reserved subjects, on the other hand, were to be administered by the governor and his Executive Council without being responsible to the Legislative Council. So what they say is that in the provincial legislatures, there were two types of subjects, that is reserved and transferred. The transferred subjects were matters which were not as important as were the reserved subjects. The reserved subjects, the British wanted to keep it for themselves. And that's why the Executive Council has more power, because it is not responsible to the Legislative Council. That is, if Executive Council decides on something, then the Legislative Council cannot vote it out, cannot vote the decision out. But when it comes to a transferred subject, the Provincial Legislative Council can vote out the decision taken. This dual scheme of governance was known as diarchy, a term derived from Greek word diarche, which means double rule. However, this experiment was largely unsuccessful. Third, it introduced for the first time bicameralism. Bicameralism is like having an upper house and a lower house. Lower house you directly elect, upper house you indirectly elect. Like in India, Rajya Sabha is indirectly elected. Members of the Rajya Sabha are indirectly elected by the members of the state legislative assemblies, who are in turn elected directly. So this house is called as an upper house, the indirect house, and lower house is a direct house. Thus, the Indian Legislative Council was replaced by a bicameral legislature consisting of an upper house called as the Council of States and a lower house called as the Legislative Assembly. The majority of members of both the houses were chosen by direct election. Although they use the word direct election, upper house, it means that there is a direct election among the people who are elected to the provincial legislatures and not direct election by the people themselves. Whereas for the lower house, there is a direct election by the people. Fourth point, it required that the 3 of the 6 members of the Viceroy's Executive Council, other than the Commander in Chief, were to be Indian. So now we have 6 people in the Viceroy's Executive Council and 3 of them have to be Indian. So Indians are like 50% of the core of the administration now. Executive Council is the core body and not the Legislative Council. As we can see here, the governor himself has an Executive Council which administers over the reserved subjects, which are actually the important subjects like law and order, finance, law, something related to law, lawmaking, etc. It extended the principle of communal representation by providing separate electorates for 6 Christians, Anglo-Indians and Europeans. Earlier, the system of separate electorate or communal electorate was to Muslims only. That is according to the Morley-Minto reforms and the Government of India Act of 1909. In 1919, this was extended to 6 Christians, Anglo-Indians and Europeans, but not to Dalits, but not to the scheduled castes. The separate electorate to scheduled castes would come into operation, not separate electorates, a system of reservation would come into operation after 1932. That is in the Government of India Act of 1935. So now we are in 1919. So 1919, except for the scheduled castes, everybody is having a system of separate electorates. Sixth point, it granted franchise to a limited number of people on the basis of property, tax or education. So now you can actually elect. So now the Indians have a chance to elect their members, but it is limited on the basis of property. Like if you own say 10 acres of land and above, you can vote. So that 10 acres of land is like the minimum qualification for you to be eligible to vote. There was no universal suffrage. Or you should be paying a minimum amount of tax, that is your income should be above a certain level, or you should have a minimum education like BSc or BE, whatever it is. Seventh, it created a new office of the High Commissioner for India in London and transferred to him some of the functions hitherto performed by the Secretary of State for India. So now we are having an India's representative office in England. So it is equivalent to recognizing India as a separate nation and not just as a colonial territory which the British would exploit. So there is some sense of India as a nation here. So first time we have a High Commission office in London. Eighth point, it provided for the establishment of a Public Service Commission, and a Central Public Service Commission was set up in 1926 for recruiting civil servants. Ninth, it separated for the first time provincial budgets from the central budget and authorized the provincial legislatures to enact the budgets. So there is some kind of a financial devolution here, that the provincial legislatures can now enact their own budgets. So they have to be strict on their own accounts and not be dependent on the center. So that's some kind of a financial autonomy being provided. 10th point, it provided for the appointment of a statutory commission to inquire into and report on its working after 10 years of coming into force. So after 10 years after the Government of India Act 1919 comes into force, there will be a statutory commission which inquires and reports whether this particular act has worked well. And that particular commission, which they talked about in the future, The statutory commission is the Simon Commission. So let's see what are the important things which are mentioned in the Government of India Act of 1919. First thing is the main thing is the diarchy. Diarchy is the provincial subjects were divided into two parts, transferred and reserved. Transferred subjects were administered by the legislative members, and whoever is responsible, whichever minister is responsible for a particular subject, he has to report to the legislative council. So legislative council has a certain check on the decisions of the government, and they can vote out whatever they don't like. That is called as being responsible to the legislative council. But when it comes to reserved subjects, they were this was administered by the executive council, and they were not responsible to the legislative council. Another important point is the creation of the bicameral legislature, that is upper house and lower house. 3 out of 6 Indians in Viceroy's executive council, extension of communal representation to 6 Christians, Anglo-Indians and Europeans, and establishment of a High Commission of India in London, and Central Public Service Commission was set up in 1926 for recruitment of civil servants. So let's go to the Simon Commission. Simon Commission. In November 1927 itself, that is 2 years before the schedule, the British government announced the appointment of a 7 member statutory commission under the chairmanship of Sir John Simon to report on the condition of India under its new constitution. By new constitution, they are talking about the Government of India Act of 1919. All the members of the commission were British, and hence all the parties boycotted the commission. That is, all Indians, like the Congress boycotted the commission. Congress was the major Indian body fighting for India's freedom and representative of Indian interests. And then there were Muslim League and other smaller parties as well. The commission submitted its report in 1930 and recommended the abolition of diarchy, extension of responsible government in the provinces, establishment of a federation of British India and princely states, continuation of communal electorate, and so on. To consider the proposals of the Commission, the British government convened 3 roundtable conferences of the representatives of the British government, British India, and Indian princely states. On the basis of these discussions, a white paper on constitutional reforms was prepared and submitted for the consideration of the Joint Select Committee of the British Parliament. The recommendations of this committee were incorporated with certain changes in the next Government of India Act of 1935. So, whatever happens in the Simon Commission can be seen in the Government of India Act of 1935. Basically, this Simon Commission had to come to India in 1929 and report on the working of the Government of India Act from 1919 to 1929. But they came 2 years earlier due to some domestic compulsions in Britain, political compulsions. But all the members of this commission were British, and hence the Indians boycotted the commission. They boycotted any kind of a consultation with Simon Commission. So let's see what are the recommendations. The main recommendations are abolition of diarchy. Diarchy, as we know, is a division of provincial subjects into transferred and reserved subjects, where the executive council has a lot more power, has a complete power over the reserved subjects, and the legislative council over the transferred subjects. Extension of responsible government in the provinces. So more power to be given to the provinces. Establishment of a federation of British India and princely states. So now, for the first time, there is a kind of integration of British India and princely states at a constitutional level. So this was envisaged for the first time. Continuation of the communal electorate. So communal electorate was again encouraged. And let's go to the next part, that is the communal award. In August 1932, Ramsay MacDonald, the British So let's go to the next part, the Communal Award. In August 1932, Ramsay MacDonald, the British Prime Minister, announced a scheme of representation of the minorities, which came to be known as the Communal Award. The award not only continued separate electorates for the Muslims, Sikhs, Indian Christians, Anglo Indians, and Europeans, but also extended it to the depressed classes or the scheduled castes. Gandhiji was distressed over this extension of the principle of communal representation to the depressed classes and undertook fast unto death in the Yerawada jail in Pune to get the award modified. At last, there was an agreement between the leaders of the Congress and the depressed classes. The agreement, known as Pune Pact, retained the Hindu joint electorate and gave reserved seats to the depressed classes. So, originally, the British planned to extend separate electorates to the Dalits. But then Gandhiji went on a satyagraha in Pune, fast unto death in Pune, and then there was an agreement between Dr. Ambedkar and other depressed class leaders and Gandhiji, and the result of which is the Pune Pact. In the Pune Pact, it was decided that the joint electorate system would be retained, but there would be a certain amount of reservation in the seats for Imperial Legislative Council and also the Provincial Legislative Council to the scheduled caste, to the members of the scheduled caste. Government of India Act of 1935. This act marked a second milestone towards a completely responsible government in India. It was a lengthy and detailed document having 321 sections and 10 schedules. The features of this act are: it provided for an establishment of an All India Federation consisting of provinces and princely states as units. The act divided the powers between the centre and units in terms of three lists: the federal list for centre, the provincial list for provinces, and the concurrent list. Residuary powers were given to the viceroy. However, the federation never came into being as the princely states did not join it. So, here there was a conception of an all India federation, that is, the territories ruled by the British. They were actually in two parts. One, they used to rule indirectly, that is, through these princes. That is, the princes had a certain kind of an autonomy, and there were British agents who were stationed in these princely states who could see that the British policies are being implemented in the states as well. The British interests are being maintained, so that the king doesn't take any decision which goes adverse to the British interest. And then there was the British India, which was controlled directly by the British. So they try to create an all India federation. A federation is a coming together of the constituent parts, of the constituent political units. They come together to achieve a common goal. Like USA is some kind of a federation where the 50 states come together, because these 50 states individually are pretty poor, pretty poor economically and militarily. But when they come together as United States, they are very strong. So, some kind of an all India federation was being tried to be put up, but it didn't materialize because the princely states did not join it. See, as a king, you have a certain kind of autonomy, you have your freedom. But when you are in a federation, you have to follow the constitution of the federation. That is the Government of India Act of 1935. So there is something which is being imposed on you from the top. And this may not be acceptable to someone who enjoys a higher amount of freedom. Point number two, it abolished diarchy in the provinces and introduced provincial autonomy in its place. The provinces were allowed to act as autonomous units of administration in their defined spheres. Moreover, the Act introduced responsible governments in the provinces. That is, the governor was required to act with the advice of ministers responsible to the provincial legislature. This came into effect in 1937 and was discontinued in 1939. So we can see that the provinces were given a larger autonomy. The British wanted to prop up local level leaders of the Congress who could counter the national level leaders. And hence, when these local level leaders enjoyed their power in the provinces, they would then not listen to the national leaders. So the British wanted to give a larger amount of power to these provinces. Okay. So there is an extension of power in the provinces. This, if you remember this, then that is enough. And diarchy was abolished. Point number three, it provided for the adoption of diarchy at the center. Now the diarchy moves from the provinces to the center. Consequently, the federal subjects were divided into reserve subjects and transfer subjects. However, this provision of the Act did not come into operation at all. Just like the All India Federation with British India and the princely states, this particular provision of the Act did not materialize at all. Fourth, it introduced bicameralism in 6 out of the 11 provinces. Thus, the legislatures of Bengal, Bombay, Madras, Bihar, Assam, and the United Provinces were made bicameral, consisting of a legislative council and a legislative assembly. However, many restrictions were placed on them. Fifth, it further extended the principle of communal representation by providing separate electorates for depressed classes, women, and labor workers. Sixth, it abolished the Council of India established by the Government of India Act 1858. The Secretary of State for India was provided with a team of advisors. I think it's more of a name change. Instead of calling it as the Council of India to advise the Secretary of State, now you have something called as the team of advisors. Seventh, it extended the franchise. About 10% of the total population got the voting right. Eighth, it provided for the establishment of a Reserve Bank of India to control the currency and credit of the country. Ninth, it provided for the establishment of not only a Federal Public Service Commission but also a Provincial Public Service Commission and a Joint Public Service Commission for 2 or more provinces. 10th, it provided for the establishment of a federal court which was set up in 1937. Federal court is nothing but a Supreme Court. Indian Indian Independence Act of 1947. As we can see here, Indian Independence Act is the last of the acts enacted by the British government. So it is very important. This act would give more and more powers to India because the British were leaving India anyways. On February 20, 1947, the British Prime Minister Clement Attlee declared that the British rule in India would end by June 30, 1948, after which the power would be transferred to responsible Indian hands. This announcement was followed by the agitation by the Muslim League demanding partition of the country. Again, on June 3, 1947, the British government made it clear that any constitution framed by the Constituent Assembly of India, formed in 1946, cannot apply to those parts of the country which are unwilling to accept it. So basically, there was this talk of a Constituent Assembly being formed, which comprises of Indians. So Indians would decide what would India's constitution be. So this Constituent Assembly is a result of cabinet mission which came to India in 1946. By then the British were clear that they are leaving India, and we were not clear whether we would have two countries or three separate regions in India with the three different constitutions for these three different regions and a uniting constitution for the union. That is what they call as parts of the country cannot apply to those parts of the country which are unwilling to accept it. So there was a issue with the interpretation of what the cabinet mission meant. So we'll get into all these things in when we study history. On the same day, June 3rd, 1947, Lord Mountbatten, the Viceroy of India, put forth the partition plan known as the Mountbatten Plan. The plan was accepted by the Congress and the Muslim League. Immediate effect was given to the plan by enacting the Indian Independence Act. So Mountbatten announced on June 3rd that we are leaving India, and the plan was accepted by Congress and Muslim League, which is also in effect accepting the part that India would be partitioned into two. The features of this act were as follows. It ended the British rule in India and declared India as an independent and sovereign state from August 15, 1947. It provided for the partition of India. This is very important. Please remember this, guys, that India was partitioned, and this is mentioned in the Indian Independence Act, and creation of two independent dominions of India and Pakistan with the right to secede from the British Commonwealth. So these two dominions had the right to come out of the British Commonwealth. Third point, it abolished the office of Viceroy and provided for each dominion a Governor General who was to be appointed by the British King on the advice of the Dominion Cabinet. So the position of Viceroy has been abolished, but there would be someone called as the Governor General. See, now it is very important. Viceroy is always a representative of the king. Now, after this act is passed, the king doesn't rule over India, so you can't have a viceroy. So the name was changed to Governor General, which is again just an administrative name. So it doesn't. It shows that we are out of British Kingdom and we are into administration again. But this fellow was to be appointed by the British King. His Majesty's government in Britain was to have no responsibility, very important, no responsibility with respect to the government of India or Pakistan. That is, you guys rule yourselves, and I have no responsibility. I take no responsibility. I take no responsibility for whatever happens in your countries. Fourth, it empowered the constituent assemblies of the two dominions to frame and adopt any constitution for their respective nations and to repeal any act of the British Parliament, including the present act itself, including the Independence Act itself. So, when the constituent assemblies of these two countries meet, of this they call it dominions till then, because until this particular act is passed, the countries wouldn't be in existence. So these two dominions and these two countries are still a part of the Commonwealth, and that is why the word dominion is used and not countries. So when these constituent assemblies of these two dominions meet separately, of course, they would frame their constitution for their respective nation, and they can repeal any act of the British Parliament which until then would apply to their respective nations, including the present Independence Act itself. The fifth point, it empowered the constituent assemblies of both the dominions to legislate for their respective territories till the new constitutions were drafted and enforced. So this is an important point. This happened in India as well. What happened is our constitution came into effect on 26 January 1950. So what happens from August 15, 1947 to 26 January 1950? There should be someone who is making the laws. So the Constituent Assembly will be making the laws. That is what this particular provision says. It empowers the constituent assemblies of both the dominions to legislate for their respective territories till the new constitutions were drafted and enforced. No act of the British Parliament passed after August 15, 1947 was to extend to either of the new dominions unless it was extended thereto by a law of the legislature of the dominion. So, if any act of the British Parliament passed by the British Parliament would not apply to these countries after August 15, 1947 until we in these two countries want it. Point number 6. It abolished the office of the Secretary of State for India and transferred his functions to the Secretary of State for Commonwealth Affairs. So this guy, Secretary of State for India, was a nodal point agent of, he was like a common window to the British government in Britain. But now there is a no now there is no need for him because India is not being administered by Britain. So this office is abolished, and his functions were given to the Secretary of State for Commonwealth Affairs. So this is a very loose body, Secretary of State for Commonwealth Affairs, because even though you are a part of Commonwealth, you are a sovereign nation. That is, India will take its own decisions. So Secretary of State for Commonwealth Affairs is more like a team of friends, group of friends, with no one ruling no one, with none ruling the other. Point number seven, it proclaimed the lapse of the British paramountcy over the Indian princely states. Very important. What it says is that the British king loses his control over not only British India but also over the Indian princely states who were independent kingdoms in themselves, and all the treaty relations with the tribal areas stand null and void. It granted freedom to the Indian princely states either to join the Dominion of India or Dominion of Pakistan or to remain independent. So they had one of three choices: to remain independent, to join India, or join Pakistan. Point number nine, it provided for the governance of each of the dominions and the provinces by the Government of India Act of 1935 till the new constitutions were framed. So I told you that the Constituent Assembly would be making the laws, but they need to have a temporary constitution under which they would do it. So this temporary constitution would be Government of India Act of 1935. So from 1947 August to January 1950, we are still ruled under the Government of India Act of 1935. Let's read the point again. It provided for the governance of each of the dominions and the provinces by the Government of India Act of 1935 till the new constitutions were framed. The dominions were, however, authorized to make modifications in the Act. But say the Constituent Assembly does not like the Government of India Act of 1935, they can say that we will not have Government of India Act. We will have the Switzerland Constitution till then. So they were free to modify it, but this is something like something of a recommendatory nature that you follow the Government of India Act of 1935. Point number 10, deprived the British monarch of his right to veto bills or ask for reservation of certain bills for his approval. But this right was reserved for the Governor General. The Governor General would have full power to assent to any bill in the name of His Majesty. So the British monarch loses his right to veto bills and asks, so the British monarch in turn loses all his control. But the Governor General still has some control. This is something very peculiar. See, the Governor, India's first Governor General is Lord Mountbatten, and he has the full power to assent to any bill, and it's given in the name of His Majesty. So this thing still exists. His Majesty, at least for the namesake, it still exists that the Governor General would sign the bills like how the President does in modern day India in the name of His Majesty and not in the name of something which is related to India. Point number 11, it designated the Governor General of India and the provincial governors as nominal heads, just like today's President and governors. They were made to act on the advice of the respective Council of Ministers in all matters. Although the Governor General would assent to any bill in the name of His Majesty, uh, he is obligated to act on the advice of the respective Council of Ministers. 12th, it dropped the title of Emperor of India from the royal titles of the King of England. So, King of England is no more the Emperor of India, and this title is discarded. Point number 13, it discontinued the appointment to civil services and reservations of posts by the Secretary of State for India. So, the Secretary of State would no longer make appointment to India's civil services and reserve certain posts, which he used to do earlier. The members of the civil services appointed before August 15, 1947 would continue to enjoy all benefits that they were entitled to till that time. So if somebody is appointed on August 14, 1947 and he is guaranteed a salary of say 10 lakhs, then from August 16, Indian Constituent Assembly cannot say that your salary would be only 10,000 and not 10 lakhs. He would enjoy all the benefits that were entitled to him till that particular point of time, the civil services. At the stroke of midnight of 14th to 15th August 1947, the British rule came to an end and power was transferred to the new for the two new independent dominions of India and Pakistan. Lord Mountbatten became the first Governor General of the new Dominion of India. He swore in Jawaharlal Nehru as the first Prime Minister of independent India. Again, Jawaharlal Nehru is not an elected Prime Minister as, as of August 15, 1947. He was just a person of consensus. The Constituent Assembly of India, formed in 1946, became the Parliament of the Indian Dominion and continued to be so till 26 January 1950. And further on, because the Indian elections were not held right on 26 January 1950, it did take some time. So we have a list of the members and what portfolios they held. That is a list of ministers in the interim government. We know that an interim government was formed just before independence, and Muslim League was also part of this interim government. So we can see Liaquat Ali Khan in finance, who did not allow the government to run, and Muslim League came out of this interim government. So you can read this for knowledge. And the members of the interim government were also the member of Viceroy's Executive Council. The Viceroy continued to be the head of the council, but Jawaharlal Nehru was designated as the Vice President of the council. So, first Cabinet of Free India, who held what post is there? Like Nehru was the Prime Minister, External Affairs Minister, Scientific Research Minister, Vallabhbhai Patel, Home, Information and Broadcasting, Rajendra Prasad, Food and Agriculture. Maulana Abdul Kalam Azad is India's first Education Minister. Dr. John Mathai, Railways and Transport. R.K. Shanmugam Chetty, Finance. Dr. Ambedkar, Law. Jagjeevan Ram, Labour. Sardar Baldev Singh, Defence. Raj Kumari Amrit Kaur, Health. C.H. Baba, Commerce. Rafi Ahmad Kidwai, Communication. Dr. Shama Prasad Mukherjee, Industries and Supplies. V.N. Gadgil, Works, Mines and Power. So, guys, we have come to the end of the first chapter, that is the historical context to the coming of this constitution, in the formation of the constitution as it is today, as envisaged by the Constituent Assembly. What were the acts which had taken place and which had led to India in its present day shape from an administrative angle? I hope you guys have enjoyed this session, this video, and we will actually go to the core topics from the next video, that is making of the constitution. I hope you enjoyed this video. Thank you.